Welcome to Badass Breakthrough. My name is Bridget Bennett. I am your host. I am a high conflict custody and divorce coach, fellow survivor of domestic abuse, and I am here to help you on your way. This show is for those who have found their way navigating co-parenting with a high conflict or narcissistic person, battling it out in family court, feeling like that journey is never going to end, maybe discovering that they are a product of a narcissistic family, and overall for those that are trying to rebuild their life after enduring abuse, whether it was through a relationship or marriage. You're in the right place. This show is for you. So let's get started on this journey together. Welcome, everyone. How are you today? I hope that you are doing very well. I wanted to, I find this topic to be one that continuously comes up in conversations. Maybe it's not, the initial point of someone contacting me, but I find evidence of this over and over again. And I want to talk about parenting plans, custody orders today, and the language that I see that is put in place. Okay. A lot of this language is actually not helpful that I'm seeing in some of these orders. I looked at one today, and the language was very specific about vacation time, holiday schedule. And it said this, that mother and father will discuss and agree upon a holiday schedule as well as a vacation schedule for the minor child. Now, I want you to ask yourself this question. Have you at any time in a relationship, post-relationship, been able to agree to anything with your ex? The answer is likely no. Okay, so if we know that the answer is no, why would we allow an attorney to put vague language like this in the orders? All right. I want to talk about the vague parenting plans and how, for me, lazy legal language becomes your ex's best weapon, right? They find loopholes, gray areas in custody orders, in the parenting plan that can help them in communication to make it look like they're really not in contempt. Every single one of you go through this at some point during your journey. The language that shows up in orders that says, again, things like the parties will discuss and agree upon a holiday schedule, the parties will mutually agree on vacation time, the parties will communicate regarding extracurricular activities. You aren't going to agree, period. The language itself is not neutral. It might appear to be neutral, but don't mistake it, right? The language is what your ex will use as a weapon against you. I see it all of the time. And when we put that language in the hands of a high conflict person, it becomes a tool for them to have endless conflict, manipulation, and contempt that you're not going to be able to enforce. Now, some people might, jump at the first occasion of their ex not following the order and immediately jump to think, oh crap, I need to file for contempt. I'm going to file for a motion to enforce. But it doesn't get you very far when you have like these things happening one time because it's not a pattern of behavior. So think about all the things we've learned so far and we've talked about, right? We want to see a pattern of behavior consistently, whether it's good or bad. For me, this language, I'm going to be honest, it comes from attorneys who do not understand high conflict dynamics and attorneys that are lazy, right? They all have templates for these orders. They have a go from, a go by form that has been filled out for parenting plans. They have templates, okay? Their paralegals don't understand high conflict dynamics, and they're just wanting to settle the case to not go forward to a hearing or a trial. That's a different story for a different day. They're using template language in your parenting plan, in your custody order. Your case is not a template case. They don't think through what happens when two people who cannot agree on any damn thing are told by a court order to just agree. Then what do we see happen? This is when we then see the involvement of co-parent counseling, parenting coordinators, right? All of these professionals that they have put in place for you to pay for over and over again. But yet, are we really seeing them help you with de-escalating the conflict or coming up with an agreement, getting to a resolution? Oftentimes, no. I've seen lately a new trend with parenting coordinators telling my protective parents to just be reasonable. Can't you just be reasonable? They know the protective parent is the reasonable one. That oftentimes we're dealing with a high conflict parent that is not reasonable and loves to push the blame onto the reasonable protective parent. There was never ever an agreement with your ex. You've never agreed to anything. This is why you're in court in the first place. So don't let an attorney convince you to put that language in your orders. What I want to do today is walk you through the categories, every category of vague language that I have come across in the years of me doing this, in parenting plans, in orders, and what I feel it costs you, and exactly the type of specific language that I encourage you to have in these orders or parenting plans. Vague language, as we know, can be very dangerous in high conflict cases. In a healthy co-parenting situation, right? Vague language is fine. Two reasonable people can work things out. Heck, maybe you know of friends who have been divorced and maybe they don't even have a custody order in place. They're able to co-parent just fine. They're friends. They show up at the kids' birthday parties together. They celebrate holidays together. Your high conflict ex is not your friend. This dynamic will not work for you in your situation. So do not compare your case to anyone else's. In a high conflict situation, vague language is an open door for your ex to do basically whatever they want and to claim that it's not a violation because there was nothing specific enough to violate. It makes it hard to file contempt on vague language. A judge cannot enforce something that was never specifically defined in your court order. Your attorney cannot write a demand letter or file a motion on something that the order never specified in the first place. So every time you are presented with an order or parenting plan that says the parties will agree, your ex is hearing this: I can say no, and there is nothing you can do about it. I have the power here. And what do they want? Power and control. Vague language also keeps you in constant communication with your ex. We don't need all this back and forth. It keeps you also dysregulated. You are consistently being triggered by your ex every time you're engaging in back and forth. They're looking for opportunities to trigger you. And then what are you doing? You're opening the door for you to be emotionally reactive. And they're like, aha, I gotcha. See? I told you she looks crazy. I told you she's crazy. Remember what we talked about last time of how family court looks at women in particular as emotional caregivers, and that automatically attacks their credibility. Every single holiday, every vacation, every school event, decisions, you have to negotiate it every single time with vague language. That is not a parenting plan. That is a machine designed to harass you over and over and over again. No wonder why some of us are walking around completely dysregulated, lots of anxiety, because we haven't been able to push the pause button for our nervous system to work through healing those parts. Specific language is protection for you. The more specific your order is, the less access your ex has to your life, and the more power you have to enforce these things when they violate it. I don't say if, I say when they violate it, because they're going to violate it. You know this. They've never consistently followed through with anything that is your kryptonite. Now, holiday and vacation language. Okay, what vague language looks like. This is what I've read day in and day out. The parties will discuss and agree upon a holiday schedule annually. Vacations will be divided equally by mutual agreement. Each parent may take the child on vacation with reasonable notice. Why does this language fail? Why does this language not protect you? Because your ex is not going to agree to shit. Every year, it's going to be a fight as to who's getting what holiday and when. Reasonable notice means nothing when your ex defines reasonable differently than you do. Reasonable notice, that's not a deadline. For them, being reasonable could be providing you 3 hours notice. For you, it's like a week in advance. Again, we cannot change who our ex is. We can set ourselves up for success by implementing specific legal boundaries. There's no defined schedule. When there's no defined schedule, means for contempt when they take the child during your time, it's few and far between because the schedule's not defined. So even though you might have agreed to something before and, oh yeah, you can have that first half of winter break and I'll take the second half. He decides he wants to take the whole damn thing. What are you going to do about it? There's no specific language in your order, so it makes for finding contempt and all these violations harder. Let's talk about some specific language, what that looks like. I have this in my order, okay? Mother shall have the child for Thanksgiving in odd numbered years, beginning at date and ending on date and time. Father shall have the child for Thanksgiving in even numbered years on the same schedule. It's an example. Each parent may take the child on one vacation per calendar year, not to exceed 14 consecutive days, X amount of days. Written notice, including destination, travel dates, emergency contact information, shall be provided no less than 30 days in advance via talking parents. In the event that the parties cannot agree on a holiday schedule modification, the default schedule in this order shall control. Not a big fan of this language, but I've seen it in an order, so I've pulled it. Every holiday needs its own defined start time, start day, end time, end day, pickup location, drop off location. If it is at a parking lot of a mall, I saw that today, where? Outside of where? Outside of the Target at this mall, in the Target parking lot. If you don't have it specific, what is your ex going to do? They're going to say, I'm having a hard time finding you. I can't find you. You're not there. I'm at the exchange location. And they're probably running late, but they're looking to blame you and make you look like the problem in communication. Christmas Eve, Christmas Day. Please do not exchange your children on Christmas Day. Please don't do it. Do it the day after, in the morning. Let kids, regardless of your feelings about it, enjoy the Christmas Day holiday with the parent that they've been with, the new gifts that they get. You celebrate Christmas with them when you get them back. New Year's, spring break, summer, Mother's Day, Father's Day, school breaks. If there's a holiday that falls on a Friday or a Monday, whoever has that weekend with a child gets that holiday. Like, be specific. Please, please, please do not add in your child's birthday. Do not add in your birthday, your ex's birthday. Like, it's just so much, right? Can you celebrate your kid's birthday anytime? Yes. Doesn't have to be on their birthday. How many times have you thrown a birthday party on the weekend of the week when they had their birthday? Often. You can do the same thing. You're going to be okay. Your kid is going to be okay. They are also going to know that you still love them. Okay? You don't need to prove to anyone that you are a good parent or that you're a loving parent. You just are. Now, some language that I see around communication and decision making. This is what vague language I have picked up on. The parties will make major decisions jointly. First of all, what the fuck is a major decision? And are you going to be able to make that jointly? Probably not. We'll come back to it. Both parents will be kept informed of medical and educational matters. Again, what does that mean? By whom? How are they going to be informed? Is there a portal at the school that they can get access to? Parents will communicate in a timely manner regarding the child. Again, remember, your definition of timely is different than your ex's definition of timely. Why this language fails? Well, joint decision making with a high conflict co-parent is not really decision making. It is a veto system that your ex uses to block everything. A timely manner is not a legal standard. This, again, means nothing to you because you cannot enforce it. Kept informed does not define the how, when, or what platform. It is not your responsibility to inform your ex of everything that they have access to, right? And they can see your kids' grades online like you can, right? What specific language looks like in orders? Okay, let's clean up some of this vagueness. Both parents shall have access to all medical, educational, and extracurricular records and shall be listed on all provider contact forms. Neither parent shall instruct any provider to withhold information from the other parent. That's pretty fucking specific. In the event the parties cannot reach an agreement on major decisions within X amount of days, mother shall have final decision-making authority on matters pertaining to medical, education, extracurricular, whatever. All co-parenting communication shall occur exclusively through talking parents. Response time shall not exceed 48 hours for non-emergency matters. A failure to respond to a message will be deemed as consent. Medical appointments shall be scheduled with no less than blank days prior, blank days notice prior, provided to the other parent via talking parents. Both parents shall have the right to attend all medical appointments. Okay, I know, I don't want him to attend the medical appointments. I don't feel comfortable. He fucking knows that, and so he's going to do it anyway. So stop caring. Stop caring so much. I know you're uncomfortable. But what is kryptonite to a high conflict narcissistic person? Your indifference. When you ignore them and you stop caring as much, they're not getting supply. So they go elsewhere to seek it. Become boring and indifferent. This is where gray rock came from. Don't use gray rock communication. It makes you look passive. Okay, that's why I use Biff. But you want to be dull and boring like a gray rock. It's the whole phrase. Now, exchange logistics and transportation language that is very vague. I've pulled this from orders that I have gone over the years. The exchanges will occur at a mutually agreed upon location. You ain't agreeing to shit we already know. The parties will share transportation responsibilities. No, that's all going to fall on you. Pickup and drop off times will be arranged between the parties. Nope, we're going to have specific pickup and drop off times listed. Specific. You're not agreeing to a location with your ex. They're going to say, no, I didn't agree to that. No, I didn't say that. So then how are you going to do the exchange if you can't agree? Any kind of like shared transportation language with no definition means constant negotiation between you and your ex, constant back and forth, constant conflict for you. We're not doing the back and forths. When we don't have defined times, again, it's hard to look at contempt to say that they're showing up late consistently. What is some specific language that I've seen look like? All exchanges shall occur at specific address. Neither party shall be required to enter the other party's residence for exchanges. I've also seen that in there. Pickup shall occur at the exact fucking time. A grace period of 15 minutes shall apply. If the receiving parent has not arrived within 15 minutes of the scheduled time, the transferring parent shall document the missed exchange and notify the other parent via platform. I actually read this. I thought it was quite clever. The missed time shall not be made up. They're late to the exchange. They're missing their time. We're not giving them the makeup time. Again, with this language. Okay, if you don't have this language, we can talk about that later. Can you offer makeup time? You could, but you also can send a message in writing of like, hey, John, I waited at the exchange location for 15 minutes. You were not there. I have returned home with our child. The child will be available to see you during your next scheduled parenting time. That's what I would say. And I would leave it alone. If there's nothing about makeup time, don't have it in there. And makeup time, makeup from what? Like, we are not splitting your child like a sandwich. You miss a meal, you miss the meal. Transportation to and from exchanges shall be the responsibility of whom? First of all, both of y'all need to be, in my opinion, meeting at a neutral exchange location. There's issues that come up with third parties. Sending the girlfriend, the boyfriend, the whoever. Neither parent shall send a third party to conduct an exchange without prior written notice and agreement. Again, you're not going to agree to it, but I've seen language like that incorporated in orders. I've also seen language like, parent can designate or shall designate a third party as their designee. This person has the ability to be at the exchanges and to do the exchanges. I've seen that in a case in particular where The high conflict person was the mom, and dad was, at times stepmom would help with the exchanges because of dad's work schedule. The child shall be exchanged with all necessary medications, clothing, school materials, personal items, whatever. Like, I've seen this stuff specifically listed out. I do believe that each parent is responsible for their own child's clothes. Don't be exchanging clothes back and forth. Okay, just don't do it. Again, do you want to receive 5 different messages in Talking Parents about how you forgot little Sally's pink sweater? And he can't find little Sally's pink sweater, and therefore he thinks that you have it. Maybe little Sally left it on the playground. Maybe little Sally left it under her bed at his house. You don't have it. What is he going to do? Continue to blame you for it. Remove the language to protect yourself. What do we do if you already have vague language in your order? Well, first I want you to audit your order, audit your parenting plan. Go through it line by line, highlight every instance of the word agree, mutual, reasonable, discuss, timely. Every single one of those words is a potential conflict that your ex is already exploiting or will exploit. So 5 words: agree, mutual, reasonable, discuss, timely. Highlight any time that those appear in your custody order or your parenting plan. Second, I want you to start documenting the impact that the vague language has. Okay, like every time your ex refuses to agree, every time the holiday schedule falls apart, the exchange is chaotic because nothing was defined, right? When we want to look at modifying and filing motions to modify orders, we want to also present information as to how the current order is not working for the parties. This is why we document those things. Okay? Third, understand that vague language is a substantial change in circumstances. It's an argument that is waiting to happen. If you cannot demonstrate that the vague language in your current order is creating ongoing conflict that harms the child, if you can demonstrate it, you have grounds for contempt, you have grounds for, ultimately, I would say, a motion to modify. The court can modify the order, putting in specific enforceable terms, removing that vague language, but you have to be able to show it. If you are currently negotiating or mediating, do not leave the table without specific language. Do not let your attorney tell you it is fine, we can work it out. It's not fucking fine. Push for every date, every time, every location, every platform, every deadline to be defined in the order itself. That is your legal boundary, and your ex is going to hate it. Good. Let them. If you are pro se and you're drafting your own proposed order, use the language that I've given you as your framework. Judges generally prefer specific orders because they reduce the number of cases that are coming back to their courtroom. Specificity is not aggressive, it is reasonable. Right? And we can present to a judge like, Judge, I really am wanting to have specific language here. I think it will reduce the amount of conflict. And, I don't know about you, Judge, but I would prefer to not be back in your courtroom again. Right? Like, you're sounding like a reasonable human being. Here's the rule of thumb for any provision in a parenting plan or custody order, right? Every provision in your parenting plan should be able to answer 5 questions. Who is responsible? What exactly is required? When it happens, specific date and time. Where it occurs, the specific location. How it is communicated. We're talking about a specific platform. I hope you're using Talking Parents. And timeline. If any provision in your order cannot answer all 5 of those questions, it is vague and it needs to be fixed. Who, what, when, where, how. You want to keep that information handy in the event that you're going to mediation. Take it into your meetings with your attorney. Use it as a checklist before you sign any document. Vague language in parenting plans is not some minor inconvenience for you. It is a huge inconvenience. It is the foundation of years of conflict, manipulation, returns to court that's going to drain you financially and emotionally. Do you think your attorney cares about the vague language as much as you do? No, because they know that you're going to be back. They want you to be back. Your attorney may not push for specific language. You have to push for it. You have to advocate for yourself. You are the one that has to live with this order, with this parenting plan, not your attorney. If you already have vague language in your order or plan, keep track of the impact that it's having. Your documentation in that regard is kind of your pathway to a modification. Apart from other things, if you are about to sign an order, do not sign anything that says the parties will agree. Make them define it before you put your name on it. Send me your questions if you have them that have come up from this conversation today. If you have specific vague language in your order right now that your ex is exploiting, let's talk about it. Let me know. As always, I hope that you found this very helpful. I love being with all of you. I love sharing these things. And you are a badass. I see how hard you are working on yourself and how far you have come. And I'm so very proud of you. Keep showing up for yourself. And I will see you again very soon. If today's episode resonated with you, make sure you share it with someone who needs it. You can find me on all platforms as Coach Bridget B, or at my website, breakingbadasscoaching.com. If you are ready to work more with me in a session, check out some of my guides, learn how to master your documentation, or join my exclusive community, you can do that through the link that'll be in the show notes. I want you to remember, you have survived this far. You've made it through this episode, and you continue to show up. You're going to continue to survive, and I will see you in the next episode.